Hello, it is certainly a pleasure to be here with you today. I am Judge Julie Sneed, and I will be giving you an overview of the state and federal system. As you know, we do have three branches of government: the legislative, executive, and the judicial. Each has its own role and responsibility. The legislative branch in the federal government does include the House of Representatives and the Senate. The legislative branch in the state government also includes a House of Representatives and a Senate. The legislative branch of government is responsible for making the laws that govern the nation and our state of Florida. The executive branch is the branch of government which includes the President of the United States and, for our state, the Governor of Florida, Ron DeSantis. The executive branch is the law executing branch. The President has the duty to take care that all of the laws are faithfully executed. The judicial branch is the branch that is responsible for interpreting the laws. The highest court in the United States is the United States Supreme Court, and the highest state in Florida is the Florida Supreme Court. Let's delve into the historical establishment of the judicial branch of government. The founders of our nation made a number of efforts to try to determine the structure of government that would best suit their vision for our republic. We were a young nation, and at a time we were governed by what's called the Articles of Confederation, which went into effect in 1781. The Confederation named us the United States of America and created what's called a League of Friendship, with each state retaining its sovereignty, freedom, and independence. The Confederation had a number of defects, including the lack of the ability to enforce laws, the lack of the ability to raise taxes directly, and there was no executive or judiciary branch in the Articles of Confederation. There were also other differences between the states that were not resolved by the Articles of Confederation. Ultimately, the problems with the Articles of Confederation led to the Constitutional Convention in Philadelphia in 1787. The Constitutional Convention in 1787. Congress agreed to call for a special convention of all representatives from each state to consider revisions to the Articles of Confederation. The call produced a convention that met in Philadelphia in 1787. Those founders drafted the Constitution of the United States. The new Constitution was very different from the Articles of Confederation. The framers expanded national power. For example, they gave the government the power to regulate commerce and the power to tax and spend to promote the general welfare. Also, in a decision called the Great Compromise, the framers agreed that the new government would have a bicameral legislature, with each state having equal representation in the Senate and representation in the House of Representatives based on each state's population. The framers also voted to create separate executive and judicial branches of government. The executive branch would be led by a single president of the United States, who was selected independently of Congress. With respect to the judiciary, the framers voted to create a national Supreme Court, and Congress was given the power to create inferior courts. The framers also reached a compromise concerning slavery, which allowed slaves to be counted as 3/5 of a person in the apportionment of seats for the House of Representatives and for votes for president in the Electoral College. The framers also agreed that the Constitution would go into effect upon ratification by only 9 of the 13 states. Let's review some of the key provisions of the Constitution. Article 3, Section 1 of the Constitution places the judicial power of the federal government in one Supreme Court and in such inferior courts as Congress may establish from time to time. That provides that tenure in good behavior for the judges of both the superior and inferior courts shall uphold and hold their offices during good behavior. There's a prohibition on reduction of salary in Article 3, Section 1 of the Constitution. Compensation shall not be diminished during their continuance in office. This creates a measure of independence for the judiciary. Judges can only be impeached for high crimes and misdemeanors in a trial conducted by the Senate. Also, the provision protecting judges from reduction in salary was not challenged. It was seen as an essential protection against political pressure from the legislature. Article 2 and Article 1. Congress has the power to constitute tribunals inferior to the Supreme Court, which consists of our Court of Appeal as well as our trial courts. The President shall nominate and shall appoint judges of the Supreme Court with the advice and consent of the Senate. There was a great debate at the Constitutional Convention regarding how the judges would be selected. Many delegates wanted Congress to elect the judges. Others wanted the President alone to select judges. The resolution was a compromise. All of the parties wanted the institutional independence of the third branch of government. Article 3, Section 2 discusses jurisdiction. The judicial power shall extend to all cases in law and in equity arising under the Constitution, the laws of the United States, and treaties, or which shall be made under their authority. Also to all cases affecting ambassadors or other public ministers and consuls, and to all cases of admiralty and maritime. Also to controversies to which the United States shall be parties, and controversies between two or more states, as well as controversies between citizens of different states. In all cases affecting ambassadors, ministers, and consuls, and those in which a state shall be a party. All of those cases fall within the jurisdiction of the United States courts. Article 3, Section 2 does also include a very important provision related to trials. A trial of all crimes except in cases of impeachment shall be tried by a jury, and such trial shall be held in the state where the said crimes were alleged to have been committed. That is a very important protection, and these are all very important provisions of our new Constitution that our founders drafted. The proposed Constitution spurred vigorous debate. People debated whether or not the Constitution should be adopted and ratified. In the 1700s, this was a major subject of debate, but they could not use social media or the television to persuade people in the public. Instead, they needed to rely upon articles or letters that were written to their newspaper. The most famous contribution to this debate was the Federalist Papers. The Federalist Papers are a series of 85 articles that were written to newspapers. The articles were written by Alexander Hamilton, James Madison, and John Jay, all under a pseudonym. The Federalist Papers urged the ratification of the new Constitution. That was a very important effort. After the publication of all of the articles in the Federalist Papers, Alexander Hamilton was later named the first Secretary of Treasury. James Madison became the Secretary of State and the fourth President of the United States, and he's also known as the father of the United States Constitution. John Jay also became the first Chief Justice of the United States. The Federalist Papers supported the establishment of the judiciary. Federalist Paper 78, authored by Alexander Hamilton, advocated for an independent judiciary. He noted that inflexible and uniform adherence to the rights of the Constitution and of individuals which we perceive to be indispensable in the courts of justice can certainly not be expected from judges who hold their offices by a temporary commission. He advocated for lifetime tenure. Periodic appointments would be fatal to their necessary independence, he felt. Also, he argued that there would be too great a disposition to consult popularity. He also maintained that judges operate as a check upon the legislative body. These are all arguments for judges' independence. The Judiciary Act of 1787. Constitution authorized Congress to establish a federal system for the courts, but the Constitution provided no details. The Judiciary Act established 3 types of federal courts: a Supreme Court with a Chief Justice and Associate Justices, circuit courts, and 13 district courts, which were the trial courts. How do courts operate? You may have heard the saying, I'm going to make a federal case out of my litigation, or I'm going to take this case all the way up to the Supreme Court. People will use these terms to imply that they feel so strongly about their position that they're going to make a federal case out of it or take their case as far as they can all the way up to the Supreme Court. The Supreme Court of the United States is, after all, the highest court of the land. It is the final authority concerning the interpretation of the law in cases arising under the United States Constitution and under federal laws. But in reality, federal jurisdiction is narrowly prescribed, and most cases cannot be brought in federal court. Most cases cannot be taken all the way up to the Supreme Court. The great majority of disputes are resolved in state courts. Generally, if your case is lost in state court, the dispute ends. Only in very narrow circumstances can a state court case be appealed all the way up to the United States Supreme Court. In fact, a state court case can be appealed to the United States Supreme Court only if the state court decision turned on federal grounds. For example, a lawsuit can be appealed to the United States Supreme Court if the case relates to claims that a state law conflicts with the United States Constitution, treaties, or laws of the United States, or where any title, privilege, or immunity arises under the Constitution or other federal laws. Now I want to talk with you more about the state versus federal court systems. The state versus federal court systems are separate. They're separate but parallel systems of court. Each pyramid at the bottom includes the trial courts. The circuit courts and county courts are the trial courts in state court. That is the location where cases are generally initially brought. Then, if you are unhappy or dissatisfied with the outcome of your case in trial court, you may appeal your case to the state appellate court. And then, if you are still unsatisfied, you may appeal up to the state Supreme Court. Again, the great majority of cases are brought and resolved in the trial court level. Similarly, on the federal side, the lower court, which is the trial court, is the United States District Court. That is where the great majority of cases are brought in the federal system, and that is where they generally are resolved. Nonetheless, if a party is dissatisfied with the outcome of their case in the trial court in the United States District Court, they can bring their case and appeal their case to the United States Court of Appeal. And again, if they are dissatisfied, they may be able to appeal their case up to the United States Supreme Court. I am a judge at the United States District Court here in the Middle District of Florida. I'm a United States Magistrate Judge. Now, there are 2 types of courts, as we just discussed. The federal courts are established under the laws of the United States Constitution to decide disputes involving the Constitution and laws passed by Congress. And on the other hand, the state courts in Florida are established under the state constitution to decide disputes involving state laws. These are separate and parallel systems. Federal courts have jurisdiction in a number of cases. They have jurisdiction in cases arising under the Constitution and laws of the United States, as well as treaties in the United States. They also have jurisdiction over disputes affecting ambassadors, public ministers, and consul, cases arising under admiralty or maritime law, cases where the United States is a party, Also, cases involving controversies between states and citizens of different states, or between a state and a citizen thereof, and foreign states. Additionally, they have jurisdiction over cases involving bankruptcy. Also, federal courts have jurisdiction over cases involving controversies between people or entities that are residents of different states. By contrast, state court handles disputes involving violations of state law, criminal as well as civil, divorce and child custody proceedings, probate and inheritance disputes, real estate questions, as well as juvenile delinquency and dependency matters. State courts also handle matters involving traffic court violations. County courts, which are the trial courts in state court, they handle matters involving up to $30,000 in dispute, excluding costs and attorney's fees. If you have a more serious matter to bring in trial court and state court, it's brought in circuit court. They handle matters involving more than $30,000 in dispute, excluding costs and attorney's fees. The great number of cases are brought in state court, and you could tell that by the types of disputes that may be brought in each jurisdiction. In state court, there were almost 3 million cases brought in state court and county court, 2.7 million cases. 787,000 cases were brought in circuit court, and 20,286 cases were appealed to the district court, the appellate court in the state of Florida, and only 2,190 cases were appealed to the Florida Supreme Court, for a total of about 3.7 million cases in state court. By contrast, in federal court, you'll be able to see from this slide a significantly lower number of cases. 28,597 cases were brought in the district court, in the trial court level in federal court. 46,317 cases were brought in bankruptcy court, and 4,430 cases were appealed up to the 11th Circuit Court, and 7,622 cases were appealed up to the Supreme Court, for a total of about 86,000 cases. That is a great number different from the 3.6 million cases that were brought in the state of Florida. There are also many more judges in the state of Florida, and that's because they have much greater litigation there. There are 7 Florida Supreme Court justices, 64 District Court of Appeal judges in the state of Florida, their appellate court, the intermediate appellate court, 601 circuit court judges, and 324 county court judges, for a total of about 996 judges in state court. By contrast, in federal court, where a smaller number of cases are brought, but from the jurisdictional discussion that we had earlier, you could see that there are also very significant, important cases that are brought in the federal court. 37 active district court judges are in Florida. That's the trial court level. And there are 17 bankruptcy judges, as well as 38 magistrate judges, which, as we discussed earlier, I am one of that 38. There are a total of 92 total judges in Florida in federal court. Primary federal courts. At the bottom, once again, are the district courts. That is the lowest level in the federal court system. There are about 94 judicial districts in the 50 states and territories. Courts of appeal, the intermediate level in the federal court system, where appeals are brought after the district court ruling. There are 12 regional circuit courts. And the Supreme Court, again, the highest court of the land in the federal system. There are 9 justices of the United States Supreme Court, and they meet in Washington, D.C. Also, the federal court system does include what's called United States Courts of Trade, as well as U.S. Courts of Federal Claims. Other Courts that are outside of the judicial branch include military courts, courts of veteran appeals, tax courts, and federal administrative agencies and boards. Also, this chart again illustrates the trial courts, the U.S. District Court, the Appellate Court, the United States Courts of Appeal, as well as the United States Supreme Court. What are the geographic boundaries of the United States Circuit Courts? The geographic boundaries are divided based on region. If you are in Florida, Georgia, or Alabama, you will appeal your case from the District Court up to the 11th Circuit Court of Appeal. If you are, for example, in California or Arizona, you would appeal your case up to the 9th Circuit Court of Appeal. And if you are in Kansas, you would appeal to the 10th Circuit Court of Appeal. The Circuit of Appeals jurisdiction is divided by geography. This is a wonderful picture of the Supremes, the women justices of the United States Supreme Court. This photograph features the first woman justice of the United States Supreme Court, Sandra Day O'Connor. Next to her is Sonia Sotomayor, Justice Sotomayor. She is a current justice of the United States Supreme Court, and she's the first Hispanic woman to serve as a United States Supreme Court justice. Next to her is Justice Ginsburg, Justice Ruth Bader Ginsburg. She passed away recently. She was a pioneering lawyer who argued many important landmark cases before the United States Supreme Court. Next to Justice Ginsburg is Justice Elena Kagan. She is also a current justice of the United States Supreme Court. Not pictured in this photograph is our newest justice of the United States Supreme Court, Justice Amy Coney Barrett. She is the 5th woman to serve as a justice of the United States Supreme Court. This is a picture of the United States Supreme Court justices before Justice Ginsburg's passing. The most senior justices of the United States Supreme Court are photographed sitting, and the most junior judges or justices are photographed standing. So in this photograph, there's Justice Breyer, who is seated. Next to him is Justice Thomas. Then the Chief Justice of the United States Supreme Court, Justice Roberts. Next to him is Justice Ginsburg. And next to her is Justice Alito. Standing is Justice Gorsuch, Justice Sotomayor, Justice Kagan, as well as Justice Kavanaugh. Again, that was a picture of the justices before Justice Ginsburg's passing. This is a current picture of the current composition of the court, and you can see in this picture Justice Amy Coney Barrett has been added. Also, it is noteworthy that among the justices of the United States Supreme Court, we have still currently 3 women justices and 1 African-American justice, Justice Thomas. In the Supreme Court, there are 9 justices, and those justices are nominated by the President of the United States and confirmed by the Senate. The Court of Appeal judges, we have 179 judges, and they're also nominated by the President and confirmed by the Senate. The United States District judges, the trial court level judges, we have 663 judges, and they are also nominated by the President and confirmed by the Senate. In Florida, we have 37 district court judges. We have 549 magistrate judges, and we have 345 bankruptcy judges, all in the country. Magistrate judges are authorized by statute, by Title 28, United States Code, Section 631. We are appointed for 8-year terms, and we're recommended by a nominating committee for selection, and then we are ultimately selected by the United States District judges. Similarly, bankruptcy court judges are also authorized by statute, Title 28, United States Code, Section 152. They are appointed for 14-year terms. They're also recommended by a nominating committee for selection, and they are selected by the 11th Circuit Court of Appeal judges. In Florida, we do have 3 federal districts. We are divided by geography as well. There is a northern district, a middle district, and a southern district. If you are a person that lives in Tampa or Orlando, for example, and you have a case that you would like to bring in trial court, in federal court, you would bring your case in the middle district in Florida. If you lived in, for example, Miami, and you would like to bring your case to federal court and trial court, you would file your case in the southern district in the district court in Florida. And if you resided, for example, in Pensacola, you would bring your case in the federal court in the district court in the northern district of Florida. Now, let's talk more about the state court system. This is a picture of the Florida Supreme Court, which is located in Tallahassee, Florida. Florida court's jurisdiction. Starting again at the bottom, there are county courts, which is the lowest state court in Florida. Those matters that can be brought in the county court are misdemeanor actions, which are criminal matters that involve a penalty of less than a year's punishment in jail, and civil cases where the amount in controversy is less than $30,000. If you have a more serious matter, that is a felony court case, that is punishable by imprisonment for a year or more, that case is brought in circuit court in Florida. If you have a family law case or a probate guardianship or case involving mental health, juvenile dependency or delinquency, those cases, including cases where the amount in controversy exceeds $30,000, those cases are brought in circuit court in Florida. Again, if you are unhappy or dissatisfied with the result in your case in circuit court, you can appeal your case to the district court in Florida. And again, if you are still dissatisfied, you may be able to appeal your case to the Florida Supreme Court. And the Florida Appellate Court jurisdiction is also divided by region. In the appellate courts, which are known as the district courts of appeal in Florida, they are divided by region. If you have had a case that you went to trial in, for example, South Florida, Miami, and you are dissatisfied with the outcome, you can appeal your case to the 3rd District Court of Appeal. If you lost your case or are dissatisfied with the ruling in Tampa in a circuit court, you can appeal your case to the 2nd District Court of Appeal. If, for example, you're dissatisfied with the ruling and you reside in Daytona Beach, Florida, you can appeal your case to the 5th District. And if you were in Orlando, for example, or that region, you would appeal your case to the 4th District, and in Pensacola and surrounding areas, you could appeal your case to the 1st District Court of Appeal in Florida. In Florida, there are 7 justices of the Florida Supreme Court, 64 judges of the District Court of Appeal, 601 judges of Circuit Court, and 324 judges in County Court. This is a picture of the current composition of the Florida Supreme Court. There are, as I mentioned, 7 justices of the Florida Supreme Court, and Justice Kennedy is the Chief Justice of the Florida Supreme Court. And as you can see here, there is one woman justice on the Florida Supreme Court currently, Justice Grosshans. I showed you a picture previously of the Supremes in the United States Supreme Court. This is a picture of the Florida Supremes. First, Justice of the Florida Supreme Court is Rosemary Barquette. Justice Peggy Quince was the first African-American woman justice of the Florida Supreme Court. Justice Pariente, Justice Barbara Lagoa, and Justice Lagoa, I will note, was the first Hispanic woman who was appointed to serve on the Florida Supreme Court. and Justice Grosshans, who is a current justice of the Florida Supreme Court. How are the justices in Florida selected? The justices in Florida on the Florida Supreme Court are selected by the governor. They're appointed by the governor after they're recommended for selection by a judicial nominating commission. They stand for retention after 6 years. In the district courts of appeal, they're also selected by the governor. They're appointed by the governor after they've been recommended for selection by a judicial nominating commission. They also stand for retention after 6 years. What about the trial court judges in the state of Florida? The trial court judges in the state of Florida are generally elected. They're elected by the citizens who vote in each of the communities. That is the case unless the judges are filling a vacancy or there is a newly created position. And in that case, the judge is selected and appointed by the governor, again after recommendation from a judicial nominating commission. And they also have a term of 6 years, and then they can stand for re-election. In sum, the state court judges in Florida are generally either elected or appointed. The appellate court judges including the District Court of Appeal judges, as well as the Florida Supreme Court justices, they are appointed by the governor after they've been recommended for selection by a judicial nominating commission. And the Florida trial court judges are generally elected, unless they are filling a vacancy or a new position has been created. Now I want to talk with you about a few landmark cases. There are any number of cases that we could discuss, but I'm going to discuss only 3 cases, including Marbury versus Madison, Brown versus Board of Education, and Gideon versus Wainwright. Marbury versus Madison is a very important case that was decided back in 1803. In that case, it stands for the very important principle that it is the province and the duty of the judicial department and the courts to decide what the law is. That is a very important principle, and it was a groundbreaking and new principle back in 1803. It's very important nonetheless. In Brown versus Board of Education, that case was decided back in 1954. The court decided in that case, the United States Supreme Court decided that separating children based on race is not constitutional. In this picture, Linda Brown, who was the plaintiff in that matter, she was one of the plaintiffs, she stands in front of the school that prohibited her from enrolling. They refused to enroll her back in 1951 because she was black. In the Brown versus Board of Education case, the United States Supreme Court ruled that schools segregated by race are inherently unequal. As a result, the court ruled that the plaintiffs were being deprived of the equal protection of the laws which is guaranteed by the United States Constitution. Thurgood Marshall, pictured here, is one of the lawyers who argued that important landmark case before the United States Supreme Court. He later became the first black justice of the United States Supreme Court, Justice Thurgood Marshall. The last case that I'd like to talk with you about is Gideon versus Wainwright. In this case, it is a landmark case in which the United States Supreme Court unanimously ruled that in criminal cases, states are required under the Sixth Amendment to the Constitution to provide an attorney to individuals who are indigent and unable to afford one. That is a very important principle that has assisted many indigent individuals to this day. You undoubtedly could find any number of other important landmark cases, and I hope that you will take advantage and do so. It has certainly been a pleasure talking with you here today. I've enjoyed talking with you about the state and federal system and some of the important landmark cases. I look forward to the opportunity to talk with you again soon.